afternoon, everyone. Welcome to another series of our In Conversation With episodes. Slight twist today. I am joined by one of my colleagues, Roddy McLeod, a partner based in our Manchester office. Good afternoon, Roddy.
Hi, everybody. How are you?
I'm good, thanks. How are you?
Yeah, it's that kind of Thursday feeling because that's when we're recording it. So
yep, absolutely.
Towards that weekend when we'll all have unlimited amount of things to do, or maybe not.
Yeah, I know. I'm looking forward to the weekend myself too. For those who don't know me, my name is Ingrid McGee. I am a partner based in Scotland. I head up the Employment, Pensions and Immigrations team. And as I said, I'm joined by Roddy, who is an expert in his field. He has been described as a very tough and experienced opponent. He has over 20 years experience in his field dealing with employers, public liability, and has particular expertise in work-related stress claims. So given that we are now easing out of lockdown, and that's shaping up to be very different depending on what sector or what business you're in, we thought now would be a good time to discuss any additional issues that may arise as a result of COVID. And given Roddy's experience in stress-related claims, we think this might be an area of concern or indeed focus for some businesses in the next few months. So I suppose starting off with, there is a bit of commentary out there at the moment surrounding these concerns about any particular claims that employees may raise in relation to stress or the indirect impact that COVID has had. And I suppose, Roddy, it'd be interesting to understand if that's a concern that you share yourself or you think is something that may be on the horizon for businesses going forward.
Yeah, thanks, Ingrid. Yeah, no, I do think it's a point that bears careful consideration, because in my experience of occupational stress, it's often set off by specific factors. So those would include where people are forced with a change in circumstance. So obviously, if you've been off work for the best part of 3 months plus and you have to return to work, that's definitely a change. It's often set off by financial reasons. So it may be that your pay has been reduced when you've been away from work, or it may be your concern is about your pay going down when you go back to work because you could be on shorter hours, or there could be some threat of redundancy. If you add all of those factors together, that's often a potent cause of stress, which is related to work in the context of pursuing a personal injury claim. So it's definitely an area which we should be interested in. And it's certainly an area that the claimant solicitor fraternity will be interested in, because they're also on the lookout for, new kind of key development areas where they can bring further claims. So at the end of the day, claimant solicitors make their money out of bringing claims from the costs they recover from successful claims. So I do think it's certainly something that bears careful consideration.
And obviously in your experience, you predominantly, or if not solely, deal with employers and defending employers in these particular claims. So what kind of advice would you be giving to them at this stage in order to, I suppose, make sure that they're in the best possible position to defend any particular claim that arises? And in addition, what kind of claims do you think they might be raising?
Well, there are obviously quite a variety of claims. There'll be a psychiatric claim, for example, based upon the fear of returning to work, the fear that the measures put in place are not sufficient or won't actually be followed in practice. And then there will be claims that will arise out of when you get back to work. So obviously, if you were unfortunate enough to develop a COVID-related condition, there might well be a psychiatric component to that. But the other area would be for those people who you might describe as the silent COVID victims. So those are the people who don't actually have any symptoms but are concerned about catching it. Mm-hmm. So I would say that those are the three main categories of psychiatric condition that could lead to a claim. What does an employer do? Well, I'm sure employers have got lots of problems. They financially have gone through a very difficult period. They're trying to get back to business, to save the business, to make sure that there's a business, going forward. But at the same time, a function of that business is looking after the employees, because if you don't look after the employees, you're not going to have a successful business. So you appreciate it'll change. Your approach will be different if you've got thousands and thousands of employees and large numbers of HR personnel and occupational health people. Obviously, if you're a smaller company, you don't have those luxuries. But essentially what you have to do is to utilize all that free advice that's out there, whether it's from the government or from Googling return to work strategies on your preferred search engine, and it will give you advice as to what to do, whether it be the writing of risk assessments, whether it be about the layout of office blocks or factories, and you should devise your policies based upon that. But remember, it's not just about writing things down. There's a huge personal component in this, and a lot is to be gained from actually spending time speaking with your employees to try and understand what their concerns are and to see if there are things that you can do about it. And it's also very important that you record what you do, because you can bet your last pound or whatever currency you want to use that there could be a dispute as to what you did or didn't say if you don't have a record of what you told your employee or employees. So it's always best to write things down. We're recording this through Zoom. Let's embrace some of these modern technologies. So if you're providing training to people, why don't you do it by a video Zoom? You then know precisely what it was that was passed on by way of information and guidance to your employees, and you'll have a record of who watched it. So let's move forward and use the tools that are available to hopefully keep everybody safe, and at the same time reduce the chance of a successful personal injury claim being brought against you.
Absolutely. And I think in previous discussions that we've had, you mentioned that I suppose one of the biggest challenges that a lot of employers have is to have to deal with change and how to communicate change, because most employees or individuals in general struggle with that. And obviously we are in changing times. So in your view, you've just mentioned things like Zoom, but I suppose communication is something that's going to be absolutely key going forward as well. Would you agree with that?
Yeah, well, communication was key before COVID, and communication is definitely key post-COVID, because if you are to stand the best chance of dissipating people's concerns, then the way you do it is by explaining the steps that you've taken to try and keep them safe. And it's not a one-off conversation. You may have an initial consultation, an initial meeting, initial Zoom call, which is recorded. But once people come back to work, you need to keep in touch with them and ask them how they are. And when you ask people how they are, if they tell you they're fine, you need to record that, because that's another one of my personal gripes, that people tend not to keep records, and they certainly don't keep records of people telling them they're fine. But if you don't do that, then in a month's time or 2 months' time, if a claim comes in, you can once again bet your last pound or other currency that there could well be a dispute as to whether your employee did in fact say that they were fine or not. And remember, in personal injury claims, besides establishing a breach of duty on part of the employer, to establish liability, you also have to establish foreseeability of injury. So you have to show that you as an employer knew or ought to have known that your employee was developing that psychiatric illness. And that is often a key defence ground in such claims. So if you have records showing that you've consulted with your employees, asked them how they are, and they said they're fine, and that's going to make it very hard for them to succeed on that foreseeability of injury hurdle.
Fantastic. And I think that's a very, very good and important point to make, because as you say, I think many employers or businesses do in fact record most things, but sometimes they fail to record what good they've done, and that they have ticked that box, the employee has agreed to certain measures or didn't raise any particular issue. And I know it's something that crops up within the employment sphere at the employment tribunal, in terms of any claims raised in respect of could be discrimination or stress at work, as it may be. So I suppose going forward, some of the commentary is also saying, look, at the end of the day, we've always had these health and safety obligations and requirements, so not much will change. But I think there will be some added focus because of COVID-19. And I think there is a huge communication piece in terms of understanding and also outlining any sort of concerns that employees do have about returning to work, because there are anxieties there that didn't and haven't existed prior to this, I think. And also those that maybe did suffer from anxiety or depression or whatever form of mental health condition that they may have, it may have also been exacerbated. And again, from an employment perspective, employers need to be aware and very much in touch with their employees about these aspects, so that they are updating themselves on what any conditions an employee may have, and also any particular reasonable adjustments that might need to be made. Again, this is all from an employment perspective. So it does very much tie in with the areas that you cover as well. So I suppose going forward for businesses, if you were to give them any sort of kind of key areas to focus on, to take away from our discussion this afternoon, what would they be?
Well, it is the one you identified before, really, the communication one. Some people seem to think that they've prepared their risk assessment or they prepared their, say, system of working, and it then gets filed away in a back room somewhere, and that's it. Well, it's not. That's just the start of the process. You need to make sure that your employees are aware of what your, say, systems of work are, what the risk assessment says.
Yeah.
You should take feedback from them to see if it can be improved. I mean, it's a two-way street.
Yeah.
Sometimes your employees are the best people to help you to come up with better ideas to aid the company and aid the workforce. There's a mutual interest there. And you do need to keep records, as I've said. If you've got a confidential counselling line, then remind people, of its availability, that it is confidential, what the number is, etc., etc. Remember, if you're an employer, unlike for most employers in terms of employment tribunal claims, you will have insurance, because employer's liability insurance is compulsory. So if one of your employees is to pursue a claim against you, it's not one that you would end up having to pay yourself unless you have an excess under your policy. But it's a condition of your policy that you notify your insurer in good time. So please don't try and think, oh, I'll get around to it, or I'll sweep it under the carpet, so to speak. That is not the thing to do. You should inform your insurer directly or through your broker as quickly as possible. And for example, I'm often instructed in cases before there's even a claim that there's a concern that there might be a claim that someone's gone off work on one occasion or two occasions, and their sick notes make reference to COVID or work-related stress. Well, if you've got situations like that, then the alarm bell should start to ring, and you can notify your insurer on a notification-only basis, and then you've then satisfied your obligation to tell them about the potential claim. And even better, your insurer may decide to investigate it, and that will then provide you with useful information that can be used to defend the claim if it comes through. But also it may provide you with helpful information in relation to perhaps improving the systems that you've already got in place. So, it's a question of working together in a team with your employees, with your insurer, with your solicitor. And if you do that, I think you've got the best chance you have of avoiding a successful personal injury claim. Absolutely.
I agree completely. And I think probably there we've probably covered off all the areas that I had hoped to cover. So thank you so much for your time, Roddy. And for anyone that's listening to our series at the moment, if anything that Roddy or I have said either rings alarm bells or makes you think, oh, we've done our risk assessment or we've done something, but we're not quite sure how well it fares in what's really expected or should be done, then feel free to contact us. I'm sure Roddy would be more than happy to pick up a call or to give some advice about these particular areas. It's not straightforward, and it's very much something we want to make sure that our clients and contacts get right as soon as possible, quite frankly. So If there's anything that you wish to discuss with us, then feel free to contact myself or Roddy. But in the meantime, thank you very much, Roddy, for your time and your expertise and sharing your wonderful insight as always. And we'll bid goodbye there. So thank you very much.